Today, the Department of Justice is suing the state of Georgia.
The Civil Rights Division did not arrive at this decision lightly. It's our job to follow the facts and the law. And in this case, our careful assessment of the facts and the law demonstrates that Georgia's recent voting rights law violates Section 2 of the Voting Rights Act. Our complaint today alleges that several provisions of SB 202 were passed with a discriminatory purpose in violation of the Voting Rights Act. Our complaint challenges several provisions of SB 202 on the grounds that they were adopted with the intent to deny or abridge Black citizens equal access to the political process. The provisions we are challenging reduce access to absentee voting at each step of the process, pushing more Black voters to in-person voting, where they will be more likely than white voters to confront long lines. First, the law prohibits election officials from distributing unsolicited applications for absentee ballots, as they did during 2020. The law irrationally shortens both the period during which voters can request absentee ballots and the period during which election officials can mail them out to voters. SB 202 imposes substantial fines on third-party organizations, churches, and advocacy groups that send follow-up absentee ballot applications and requires new and unnecessarily stringent identification requirements to obtain an absentee ballot. During the 2020 election cycle, the 4 most populous counties in the metro Atlanta area provided over 100 drop box locations for voters. Under the bill, that number is expected to drop to roughly 20.
The Civil Rights Division continues to analyze other state laws that have been passed, and we are following the progress of legislative proposals under consideration in additional states. Where we believe the civil rights of Americans have been violated, we will not hesitate to act.